In 2015, a 7-member panel of the Supreme Court of Nigeria delivered a ruling that most politicians have tried their best to forget. The case was Abegunde versus Ondo State House of Assembly. The subject, a lawmaker who defected from Labour Party to APC and argued he had the right to keep his seat because of a factional dispute inside his former party. The Supreme Court said no. It ruled unanimously that a legislator who defects from the party that sponsored their election automatically loses their seat unless there is a factional crisis at the national level of that party, severe enough to make it impossible for the party to function. State-level disputes do not count. Personal ambition does not count. The law applies without exception. That ruling is now the legal foundation of a federal high court suit filed in Abuja that targets 28 members of the Rivers State political establishment, including Kingsley Chinda, Wike's governorship candidate, and 27 state assembly lawmakers who form the backbone of Wike's entire political machine. The suit is asking the court to declare all 28 defections unconstitutional, to void all their seats, to bar every one of them from contesting the 2027 elections, and to compel INEC to reject any nominations submitted in their names. If it succeeds, there is no governorship candidate, there is no legislative bloc, there is no 2027 structure. Wike's entire Rivers political project collapses before a single ballot is cast. The question is not whether the case is strong. The question is, why has the most powerful political operator in the South-South not found a way to stop it? Before we go further, if you're new here, Ninja Brief exists for one reason: to give Nigerians the political analysis that mainstream media won't. Whether you're in Abuja, Lagos, Kano, Port Harcourt, or London, this channel is for you. Hit subscribe and stay with me. This gets deeper. The 2015 Supreme Court ruling, the original nuclear option. Let us start at the foundation. The Abegunde versus Ondo State House of Assembly ruling of 2015 was decided by a full 7-member Supreme Court panel. It was not a narrow technical ruling. It was a clear constitutional statement on what happens when a legislator defects. The ruling said this: Section 68(1)(g) of the 1999 Constitution is unambiguous. A member of the National Assembly who ceases to be a member of the party that sponsored their election vacates their seat. The only exception is where there is a division in the political party at the national level that makes it impossible for the party to function. State-level disputes do not count. Personal ambition does not count. The law applies without exception. That ruling is now the legal foundation of a federal high court suit filed in Abuja that targets 28 members of the Rivers State political establishment, including Kingsley Chinda, Wike's governorship candidate, and 27 state assembly lawmakers who form the backbone of Wike's entire political machine. The suit is asking the court to declare all 28 defections unconstitutional, to void all their seats, to bar every one of them from contesting the 2027 elections, and to compel INEC to reject any nominations submitted in their names. If it succeeds, there is no governorship candidate, there is no legislative bloc, there is no 2027 structure. Wike's entire Rivers political project collapses before a single ballot is cast. The question is not whether the case is strong. The question is, why has the most powerful political operator in the South-South not found a way to stop it? Let us start at the foundation. The Abegunde versus Ondo State House of Assembly ruling of 2015 was decided by a full 7-member Supreme Court panel. It was not a narrow technical ruling. It was a clear constitutional statement on what happens when a legislator defects. The ruling said this: Section 68(1)(g) of the 1999 Constitution is unambiguous. A member of the National Assembly who ceases to be a member of the party that sponsored their election vacates their seat. The only exception is where there is a division in the political party at the national level that makes it impossible for the party to function. State-level disputes do not count. Personal ambition does not count. The law applies without exception.
The Chinda dimension, the governorship candidate's own problem. Kingsley Chinda's situation is separate from the 27 lawmakers and in some ways more immediately critical. Chinda won the Rivers APC governorship primary on May 21, 2026. He had been the minority leader of the House of Representatives on a PDP platform. His defection letter was announced by the House Speaker on June 2, 2026, 12 days after the primary. His defection letter was dated April 23, 2026. ALDRAP's argument, backed by a separate set of lawyers, relies on a specific Supreme Court requirement. For a legislator's defection to be legally valid, it must be formally announced in plenary by the Speaker. That formal announcement did not happen before the May 21 primary. It happened after. The lawyers cite the Supreme Court's February 2025 ruling in the Rivers crisis itself, which reinforced the Abegunde procedural requirement. They say, Honorable Chinda's defection is illegal because only the Speaker can declare any legislator to have defected during plenary. The formal announcement of Chinda's departure from PDP was read in the House on June 2, nearly 2 weeks after he won the APC governorship primary. Chinda's defense team says he resigned from the minority leadership position effective April 2, ceased performing minority leader functions, and was therefore within the constitutional timeline. The Center for Constitutional Governance and Electoral Integrity described the ALDRAP suit as misleading, politically motivated, and lacking constitutional substance. But here is the specific evidentiary question the court will have to answer. Is there a Hansard record showing Chinda formally notified the House of his departure from PDP before the primary? ALDRAP made a Freedom of Information request for exactly that record. The answer to that request will be one of the most consequential documents in Rivers state politics before July 2026. The Okocha chairmanship nullification, the third pillar. Running parallel to the ALDRAP suit is the Okocha chairmanship crisis. On May 29, 2026, the Court of Appeal in Port Harcourt upheld the nullification of congresses that produced Tony Okocha as APC chairman in Rivers. Justice Elfrida Williams-Dawudu affirmed the Rivers State High Court's earlier ruling. Okocha is Wike's man. Every primary that produced every Wike-aligned candidate, governorship, Senate, House of Representatives, State Assembly, was conducted under Okocha's leadership. The Beke faction's position is now formally on record. All actions taken by the Okocha faction between December 20, 2024 and May 29, 2026 are illegal, null, and void. That window covers every primary, every candidate, the entire 27 ticket. Wike's response to the Okocha ruling is wait for INEC's July candidate list. He says Beke does not understand the issues. He says there is no threat. The APC National Working Committee, which recognized Okocha, still backs the primaries. But the NWC backs it, and 2 courts have now said it was void, are not the same thing. INEC must make a legal determination, and INEC has its own incentive to avoid certifying candidates whose elections emerged from a structure that the appellate court has confirmed was illegitimate. Here is the confounding effect that makes these 3 legal challenges together more dangerous than any one of them separately. They operate on different legal tracks, meaning defeating one does not defeat the others. You could win the Okocha chairmanship in the Supreme Court and still lose the Chinda defection case. You could survive the ALDRAP suit on the 27 lawmakers and still find Chinda's candidacy voided. You could win all 3 at the federal high court level and face appeals that keep the uncertainty alive past INEC's July deadline. The architecture is designed for maximum compounding uncertainty. Hold this.
Section 68(1)(g). The constitutional mechanism. Let me explain precisely why the Abegunde ruling is being called the nuclear option. Section 68(1)(g) of the 1999 Constitution states that a member of the National Assembly vacates their seat if, being a person whose election to the House was sponsored by a political party, he becomes a member of another political party before the expiration of the period for which that House was elected. The proviso allows an exception only where there is a division in the political party of which he was a member. The Abegunde ruling defined what that division must look like. It must be at the national level of the party. It must be severe enough to make the party impossible to function as a party. State factional disputes do not qualify. Internal personal rivalry does not qualify. Now, apply this to December 2023. 27 Rivers State Assembly members defected from PDP to APC. They cited PDP's internal crisis. But PDP's crisis was concentrated at the state level in Rivers. It was the Wike Fubara power struggle within a state PDP structure. The national PDP continued to function. It had its national executive. It had its national convention. It was not dissolved. It was not incapable of functioning. ALDRAP's affidavit makes this argument directly. By April 2026, the PDP had stabilized. It had resolved its internal leadership disputes and conducted primaries. The constitutional exception that might have been invoked in December 2023, if it was ever valid, certainly cannot be sustained through to 2026. And under Abegunde, a defection that does not meet the constitutional standard is void from inception. The Speaker announcement requirement, Chinda's specific vulnerability. The Chinda case turns on a procedural constitutional requirement that sounds technical but has enormous consequences. The Supreme Court's February 2025 ruling in the Rivers crisis itself, the ruling that validated Amaewule's assembly and which Wike celebrated as his greatest legal victory, included a restatement of the Abegunde requirement. For a legislator's defection to take legal effect, there must be a formal declaration during plenary, not a letter, not a backstage communication, a formal floor announcement read by the Speaker. Chinda's letter was dated April 23rd. The Speaker's announcement came on June 2nd. ALDRAP made a Freedom of Information request asking the Speaker to produce any Hansard showing Chinda's defection was formally declared before the May 21st primary. No such Hansard has been publicly produced. If the court finds that there is no Hansard record of a formal floor declaration of Chinda's defection before May 21st, then under the Supreme Court's own standard, his defection had not legally taken effect when he contested the APC primary. A candidate who had not legally defected from PDP contesting an APC primary is legally in a position that is constitutionally untenable.
Here is the deepest irony in this entire story. The Supreme Court ruling of February 2025, the case of Rivers State House of Assembly and Ano versus the government of Rivers State, was Wike's most decisive judicial victory. It validated the Amaechi Assembly. It imposed costs on Fubara. It handed Wike control of the Rivers legislative structure. That same ruling, in reaffirming the Abegunde procedural requirements, created the legal standard that ALDRAP is now using to challenge Chinda's candidacy. Wike's biggest win became part of the legal architecture being turned against him. The INEC July deadline, the clock that makes everything urgent. The reason these three legal challenges are racing against time is the INEC candidate certification deadline. INEC is scheduled to publish its final list of candidates for the 2027 elections in July 2026. Once that list is certified, the window for pre-election injunctions closes. After certification, challenges must go through election petition tribunals operating under different rules and timelines. An injunction restraining INEC from certifying Chinda as the APC governorship candidate, even on an interim basis, before the July deadline would change the entire trajectory of Rivers 2027.
It would force INEC into a legal consultation window. It would open a question about substitute candidates, and it would revive the conversation about the Rainbow Coalition's actual candidate selection process. And it would do all of this while Fubara is still governor with full executive authority, with 12 months of patronage and appointments available to him. There is a specific legal contradiction inside Wike's camp that has not yet been adequately examined. The February 2025 Supreme Court ruling was decided by a 5-member panel. The Abegunde ruling of 2015 was decided by a 7-member panel. Under the principle of judicial hierarchy, the larger panel's ruling takes precedence when there is a conflict. ALDRAP's lawyers cited both rulings. If the Federal High Court must choose between the 5-member February 2025 decision and the 7-member 2015 Abegunde standard on the question of what constitutes a valid national-level party crisis for defection purposes, which takes precedence, that is the question that must eventually reach the Supreme Court, and it is a question where the answer is not as certain as Wike's camp would like. Hold this. What Wike has and what he is risking. Let us start with an honest assessment of Wike's current position. He controls the Rivers APC structure through the Okocha chairmanship, disputed but still functioning. He has the APC NWC's backing. He has the Rainbow Coalition spanning APC, PDP, Labour Party and Action Alliance. He has the 23 LGA chairmen. He has Tinubu's effective body language support. And he has Chinda as the APC governorship flag bearer. What he is risking is all of it simultaneously. If ALDRAP's suit succeeds on the 27 legislators, Wike loses his legislative bloc before the 2027 election. If the Chinda eligibility challenge succeeds, he loses his governorship candidate. If the Okocha chairmanship nullification is upheld by the Supreme Court, or if INEC declines to certify candidates from a primary conducted under an invalidated structure, he loses the entire ticket. 3 judicial bets, each with meaningful probability of going against him, each operating on a timeline shorter than the INEC certification window.
The Fubara calculation, invisible but present. Fubara has not publicly commented on any of the 3 legal challenges. He does not appear on any court document. His name is not in any filing. But he is still governor of Rivers State until May 29, 2027. He still controls state patronage, appointments, and contracts. Litigation is expensive, requires sustained briefing, and benefits from institutional cooperation. A sitting governor who wants a legal challenge to be well-resourced and well-argued has every available resource to support that objective without ever appearing in the courtroom. ALDRAP has members from Chinda's own Obio Akpo constituency. The Beke faction's legal challenge is backed by the Amaechi bloc. These are not organizations that Fubara controls directly. But the motivation for sustained, well-argued litigation and the resources available to sustain it are not unrelated to the political interests of a governor who spent 3 years being systematically excluded from his own party's primary structure. Fubara called Wike's bluff on the peace deal. He forced the public disclosure of the terms. He framed his withdrawal as sacrifice, not surrender. Now 3 legal traps are closing on Wike's structure, and Fubara is quiet. In Nigerian political analysis, when the most affected actor goes quiet, it usually means they are watching something work. The Amaechi factor, the architect in the shadow. Rotimi Amaechi has been conspicuously silent throughout the entire Rivers crisis. His loyalties back the Beke faction, which is the APC structure that predates Wike's entry into the party's internal machinery. If the Okocha primaries are voided and a fresh primary must be conducted under the Beke structure, who benefits? A fresh Rivers APC primary conducted by an Amaechi-aligned chairman would be contested by different candidates. Toye Cole, Amaechi's preferred candidate, who has lost the governorship twice and who explicitly refused to step down for anyone before the primary, would be in that contest. Whether Cole wins or not, the outcome would be a governorship ticket that is not Wike's. The ALDRAP suit that looks like a Fubara operation may simultaneously be an Amaechi repositioning. In Rivers State, the 2 possibilities are not mutually exclusive, and Wike, who has spent 3 years deploying the judicial system against Fubara, is now facing a judicial challenge whose architects are invisible and whose motivations may be plural. In January 2026, APC National Secretary Ajibola Basiru publicly told Wike to resign from the Federal Executive Council.
He said a minister cannot use the leverage of federal office to cause confusion within a party organ. That statement was significant because it came from inside the APC's own national leadership. It signaled that Wike's cross-party manipulation of Rivers APC from his position as FTC minister had internal critics even within the administration he serves. If the Okocha primaries are voided and Wike's structure is judicially delegitimized, the Ajibola Basiru position becomes the institutional baseline for how the APC NWC will be expected to respond. That internal APC voice is another pillar of the legal trap. The electoral arithmetic if the traps succeed. If all three legal challenges succeed before INEC's July deadline, the 2027 Rivers governorship contest looks entirely different. Chinda is off the ballot. The APC must conduct a fresh primary under the Becker structure, a primary that Amaechi's camp and potentially Fubara's allies influence. The 27 Wike loyal assemblymen lose their seats in by-elections that are held in constituencies now open to opposition candidates. The Rainbow Coalition's legislative and structural architecture is dismantled before the election cycle even begins. In that scenario, the 2027 Rivers governorship becomes a genuinely competitive race. Fubara's allies, potentially on PDP, NDC or ADC platforms, contest the assembly seats. Ijaw and Ogoni communities, which were angry at Fubara's APC primary withdrawal, have a political vehicle. The riverine LLJs, which form a significant portion of Rivers' electorate, are contested rather than delivered. Wike's entire 2027 project has been built on the assumption that judicial outcomes in Rivers favor him, as they did in the February 2025 Supreme Court ruling. The current litigation landscape is asking a different question. Does that assumption still hold? Now, if what I just told you surprises you, drop a comment below. I want to know your reaction before we get to the part that changes everything.
The national precedent, what every Nigerian should watch. The ALDRAP suit is not just a Rivers story. It is a test of whether Section 68(1)(g) of the Nigerian Constitution means anything in practice. If the Federal High Court finds that 27 legislators who defected en masse from one party to another in circumstances that did not meet the constitutional standard for defection and then immediately used their legislative positions to impeach their governor, withhold appropriations, and destabilize their state, did all of that while sitting in seats they had legally vacated, then the remedial action is not just political, it is constitutional. Those seats were not theirs to occupy. Every decision made by that assembly was made by a body that, under strict constitutional interpretation, may not have had the members necessary to constitute a lawful quorum. That is a legal question that extends beyond Rivers. It asks, in how many other states have defection provisions been violated in ways that corrupt the legislative process? And if the courts begin answering that question strictly, as the Abegunde ruling requires them to, how many other state legislative decisions are similarly vulnerable? The economic cost to Rivers people. For the ordinary Rivers State resident, 3 years of governance crisis have meant real and documented costs: budget paralysis, delayed infrastructure, contractor uncertainty, school neglect. The legal landscape adds another layer of uncertainty. Investors do not commit to long-term projects in states where the governance structure is under active judicial challenge. Contractors do not mobilize where payment authority is unclear. Rivers State is the second largest contributor to Nigeria's federation account. The governance crisis has not stopped oil revenues from flowing, but it has redirected the political energy that should be managing those revenues toward factional survival. Diaspora and international dimension. For Nigerians in the United Kingdom, the United States, and Canada with roots in Rivers State, the legal trap story matters practically. Remittances, property investments, and business decisions in Rivers State are all affected by governance continuity risk. A governorship race whose leading candidate is under a disqualification suit at the Federal High Court level before INEC has even published its candidate list is not a stable investment environment. And for international election observers, Nigeria is scheduled to hold its 2027 general elections with ECOWAS monitoring and AU observer missions. A Rivers State governorship contest complicated by candidate eligibility litigation,
chairmanship nullification, and mass legislator seat vacations will attract specific scrutiny about whether INEC is applying its candidate certification process consistently and impartially.
The strongest defense of Wike's position. The most credible defense of Wike's entire political structure goes like this. On the 27 lawmakers, the PDP was genuinely in crisis in December 2023 in Rivers State, and the national PDP stability was not a settled question at the time of defection. The constitutional exception does not require a total national party collapse, it requires a division. Rivers PDP's crisis had national dimensions, including a Supreme Court battle over the national chairmanship. The Abegunde standard has also been complicated by subsequent rulings, including a 5-member panel ruling that has created jurisprudential tension with the original 7-member Abegunde decision. Courts are not bound to apply Abegunde mechanically if there are good arguments that subsequent rulings have modified the standard. On Chinda, his team says he resigned from the minority leadership effective April 2, seized all minority leader functions, was formally included in the APC membership register submitted to INEC before the primary, and met the requirements of the Electoral Act 2026. The June Speaker announcement was an administrative formalization of a political fact that had already occurred. The Constitution does not specify that the Speaker's announcement must precede the primary election. It requires that the formal departure from the party be communicated. On the Okocha chairmanship, the APC-NWC, which is the supreme governing body of the party, recognizes the Okocha executive. National party authority takes precedence over state court findings in intra-party disputes. INEC defers to national party leadership on internal structural questions, where the defense encounters difficulty. On the 27 lawmakers, the Abegunde panel was 7 members. It was decided unanimously. The principle it established that a state-level party crisis does not meet the national-level exception has been reaffirmed by the Supreme Court multiple times. PDP's national leadership dispute was substantially resolved by its December 2023 convention before the Rivers legislatures defected. The timeline is close, but the factual case is difficult. On Chinda, ALDRAP's FOI request for the Hansard has not produced a pre-primary floor declaration of Chinda's defection. If that declaration does not exist in the parliamentary record, Chinda's defense of a backdated letter faces a constitutional standard that requires procedure, not substance. On the Okocha chairmanship, 2 courts have now agreed. The High Court and the Court of Appeal are not the same level. When an appellate court affirms a trial court's constitutional finding, the presidential weight increases materially. The APC-NWC's preference is a political position. INEC's legal obligation is to certify candidates from the party's legitimate leadership. Those 2 things are now in direct tension. Misconception. These are nuisance suits that will be dismissed before July. The ALDRAP suit specifically invokes a unanimous 7-member Supreme Court ruling from 2015 and a Supreme Court clarification from February 2025 on the same procedural defection question. It is professionally filed with detailed affidavits naming the specific Hansard records it requires. It will not be dismissed in weeks. The uncertainty it creates is precisely what is strategically intended. What to watch before the INEC July deadline? First, the Federal High Court's response to any application for an interim injunction restraining INEC from certifying Chinda. If that injunction is granted even on an interim basis, the July certification window becomes legally complicated and potentially contested. Second, the Hansard request outcome. Whether ALDRAP's FOI request produces a pre-primary floor declaration of Chinda's defection is the single most consequential factual question in the entire litigation. Watch that specific document. Third, the APC-NWC's formal response to the vacate declaration that all Okocha-era decisions are void. The NWC must either publicly reaffirm those decisions, knowing they are judicially contested, or open a reconciliation process that would require fresh primaries. Both paths have political costs. Fourth, watch Amaechi.
If he publicly endorses Tonye Cole or any candidate for a potential Fresh Rivers APC primary, it confirms that the Beke faction's legal challenge is part of a broader repositioning strategy, not merely a constitutional compliance exercise. Fifth, watch INEC's legal opinion on the Okocha chairmanship nullification. The commission has its own lawyers and its own liability exposure. If it certifies candidates from a party structure that two courts have declared illegitimate and those candidates are subsequently disqualified by a higher court, INEC's institutional credibility takes a serious hit. That institutional self-interest may produce a more cautious certification posture than Wike expects.
We opened with a question. Why has the most powerful political operator in the South-South not found a way to stop these legal challenges? Here is the measured answer. He has not stopped them because the tools available to him were built for a different target. Wike spent 3 years deploying the judiciary against Fubara, using the courts to paralyze the governor, validate his assembly, and extract a constitutional concession. He mastered the art of judicial warfare in Rivers State politics. But the ALDRAP suit is not using the judicial system as a weapon of political management. It is using the judicial system as a constitutional accountability mechanism. That is a different instrument. And the precedent it is invoking, a 7-member Supreme Court panel, unanimously decided, reaffirmed multiple times, is not a ruling that political pressure can simply override. Wike can work the INEC process, he can work the APC NWC, he can deploy his political capital to manage the outcomes, but he cannot change what the Supreme Court said in 2015. He cannot make Chinda's defection announcement appear in the House Hansard on a date it was not recorded, and he cannot unwind the Court of Appeals ruling on Okocha's chairmanship through a political press conference. The legal trap is not designed to destroy Wike. It is designed to create a condition of sustained uncertainty that forces his camp to fight on multiple fronts simultaneously, consuming resources and attention until the INEC deadline passes in one of two ways, either with his candidate certified under a cloud of litigation that will persist into the election itself, or with the certification delayed while the courts resolve what the Constitution actually requires. Either outcome serves the same strategic purpose, not victory, uncertainty. And in Nigerian 2027 politics, uncertainty is the weapon of people who know they cannot win in a straight fight. The compounding effect is the answer to the question of why these three challenges are more dangerous together than separately. Each one forces a different response from a different institutional actor, the Federal High Court on Chinda, the Court of Appeal on Okocha, and the APC NWC on the primary structure. Wike must win on all three fronts simultaneously. His opponents only need to win on one front before July to fundamentally disrupt his 2027 architecture. The asymmetry of the burden favors the challengers. The 5 versus 7-member panel tension is the deepest legal question in this entire story. If the ALDRAP suit eventually reaches the Supreme Court, the court will have to clarify whether the February 2025 5-member ruling modified the 7-member 2015 Abegunde standard on national-level party division requirements. That clarification will have implications not just for Rivers State, but for every defection dispute in every state in Nigeria. It is genuinely a constitutional case of national significance dressed up as a Rivers governorship dispute. Here is the reform argument that this entire story demands. Nigeria's 1999 constitution is clear. Legislators who defect unconstitutionally vacate their seats. The Electoral Act is clear. Candidates must meet constitutional requirements. INEC's mandate is clear. Certify only eligible candidates. But the system has been operating for decades in a gray zone where political power overrides constitutional clarity. The ALDRAP suit is not asking for something new, it is asking for what the Constitution has always required. The reform demand is not for new legislation, it is for existing law to be enforced by every institution, courts, INEC, and the APC NWC with the same consistency that was applied in Abegunde in 2015. If it is, Wike's structure falls. If it is not, Nigeria adds another precedent that says the Constitution applies to some politicians and not others.
What ordinary Nigerians can do is specific. Demand that INEC publishes its legal opinion on the Okocha chairmanship nullification before certifying Rivers APC candidates. Demand that the National Assembly's relevant committee reviews the ALDRAP suit's constitutional argument and issues a public position on whether the defection standard is being consistently applied. And if you are in Rivers State, register, stay registered, and ensure that whatever the courts decide, the final decision about your governor is made at your polling unit, not in a chambers or a party secretariat. If this analysis gave you clarity, share it with one person who needs to understand what is really happening in Nigeria. Like, subscribe, and I will see you in the next one.